the owner of the cow said, never mind unreasonable, there was a statute that said you were supposed to have a fence, and you didn't have a fence. You violated the statute, and that proves you were negligent. Well, remember, that proves the railroad was negligent only if the statute was designed to prevent cows from eating poisonous weeds. Was it? Well, look, I don't know. You don't know why the legislators wrote that statute, but I do know this. Poisonous weeds grow all over the place, on the railroad tracks, off the railroad tracks. So putting a fence on both sides of the railroad tracks really would not have prevented a cow from eating poisonous weeds. So the statute could not have been designed to protect against this risk, and the violation of that statute does not prove negligence. It's still going to be necessary to talk about whether the defendant's conduct was reasonable. On the other hand, suppose that the statute says you're supposed to stop when you come to a red light. And I happen to be walking across the street and traffic coming toward me has a red light against it, but the defendant goes right through the red light and strikes me. Well, red lights, traffic lights in general, are installed for the purpose of regulating traffic so that people who look at the lights will know what to expect from traffic that's coming by. So the law that says you've got to stop at red lights probably was designed to protect pedestrians, because they can look and see that the light is green for them means it must be red for the cars, and the cars have to stop, so I know it's safe to walk, and I walk. Since that statute was designed to protect pedestrians against being struck by cars, then the defendant's violation of that statute may prove that the defendant was negligent, without regard to whether the defendant acted reasonably or not. But I want to warn you, if you're taking an exam, when you come to the issue of breach, you better talk about whether the defendant's conduct was reasonable. Then when you finish that, you can go ahead and talk about violation of statute, if there were any statutes given you in the exam facts. Sometimes courts say that the violation of statute, when it's relevant at all, establishes negligence. Absolutely. They use the expression negligence per se. You violated the statute, you were negligent. There's nothing more to be said about it. Some courts say that violating a statute is just evidence that the jury can consider in deciding whether you were negligent or not. But most of the time the courts say that violation of statute establishes negligence unless the defendant can show some excuse for violating the statute. And the typical excuses that those courts are willing to hear are, I tried to obey the statute, but circumstances beyond my control prevented me from obeying the statute. For example, I was pulling up at the red light. I know the law says I'm supposed to stop. I tried to stop, but there was an oil slick on the road that I couldn't see, and so I skidded right through the red light. I tried to obey the statute, but circumstances beyond my control prevented it. Another excuse the courts are sometimes willing to accept is that there was an emergency which made it safer for me to violate the statute than to obey it. I know the law says that I'm supposed to remain in the right lane when I'm driving, but there was a child lying in the roadway in the right lane, and the only way I could avoid striking the child was pulling into the left lane and striking the plaintiff's vehicle. Now, it may be that I was negligent, but if the court is willing to accept my excuse, my violation of statute won't prove that I was negligent. The plaintiff will have to prove it by showing that I failed to act reasonably. Let's talk for a moment now about an area of the law of breach. Really, this relates to establishing breach, called res ipsa loquitur. My goodness, if anything scares, frightens, and confuses law students, it tends to be res ipsa loquitur. And I'll tell you the reason. Res ipsa loquitur really is not a law of torts. It's a law of evidence, which we have adopted in the law of torts. And in particular, res ipsa loquitur involves circumstantial evidence. And most of us learned our law by watching television programs in which some lawyer stands up and objects by saying, Your Honor, that's circumstantial evidence. And the court says, no circumstantial evidence in my court. The truth of the matter is there's really nothing wrong with circumstantial evidence. Circumstantial evidence is proof of one thing from which another can be inferred. Well, no, I didn't see the defendant shoot the victim, but I saw him go running toward the victim's house with a gun in his hand, shouting, "I'm going to kill him, I'm going to kill him, I'm going to kill him." I heard some gunshots. I ran over there and I saw the plaintiff lying on the ground in a pool of blood and the defendant standing over him with a smoking pistol in his hand. All of that is circumstantial evidence from which we can infer that the defendant is the one who shot the plaintiff. No, I didn't see anybody walk past my window last night, but when I went to sleep, I looked out and there was snow without a mark on it. When I woke up in the morning, there were footprints in the snow. No, I didn't see anybody walk there, but from the circumstantial evidence, I can probably infer that someone did. Now, way back about 150 years ago, a guy named Byrne was walking down a street in Liverpool, walking past a warehouse where barrels of flour were stored, when suddenly a barrel of flour rolled out of a second-story window and struck Byrne as he went by. Byrne sued the owner of the warehouse, a guy named Bodle. And Byrne said, "Bodle, I don't know what you did, but it must have been negligent." Bodle's lawyer said, "Your Honor, it's Byrne's job to prove that my client acted unreasonably. And if he can't show what my client did that was unreasonable, this case should be dismissed." And the judge said, "Well, I don't agree with you." The judge said, "The circumstantial evidence here really points at Bodle. I'll tell you why. Barrels of flour don't usually roll out of second-story windows unless somebody does something negligent. From that circumstance, we can infer that somebody acted negligently." Now, there wasn't anybody in the warehouse except Bodle and Bodle's employees, and Bodle is responsible for what his employees do, so if anybody was negligent, it must have been Bodle or somebody for whom Bodle is responsible. From the circumstantial evidence that a barrel rolled out of a second-story window, we can infer that Bodle must have done something negligent. Now, if that had been all that the judge said, I don't think anybody would have thought twice about the case of Byrne against Bodle. But suddenly, at the last minute, the judge switched over to Latin. Instead of saying, "The circumstantial evidence is very convincing," the judge said, "You see, res ipsa loquitur." Now, the judge was actually quoting from Cicero, the ancient philosopher. The judge said, "There are some things of which it may be said res ipsa loquitur," and this is one of them. Now, res ipsa loquitur is just a Latin phrase that Cicero used that means the thing speaks for itself. And that's all the judge was doing. He was being fancy. But somehow, this kind of circumstantial evidence took on a special Latin name in the law. People started saying, "Oh yeah, that's res ipsa loquitur. That's a res ipsa loquitur case. That's a case of res ipsa loquitur," when all they really meant was this. The accident that happened here was the kind of accident that does not usually happen without negligence, so somebody must have been negligent. And there wasn't anybody else it could have been but the defendant, so the defendant must have been negligent. It wasn't the plaintiff that dropped the barrel of flour on his own head. So when those three circumstances come together, the courts, even to this day, say, res ipsa loquitur, the thing speaks for itself. Let's let the jury decide whether they think that the defendant did something negligent. What are those three circumstances? The circumstantial evidence from which negligence can be inferred. First, the accident was the kind of accident that does not usually happen without negligence. Barrels of flour don't usually roll out of second-story windows without negligence. Second, the defendant was the only one around who could have been negligent. Sometimes the courts say the defendant was in exclusive control of the instrumentality that caused the harm. And finally, the plaintiff didn't do it to himself. When all three of those things come together, we can infer that the defendant was negligent, which means simply that the jury gets to decide. Res ipsa loquitur. All right, now we have talked about negligence as a basis of liability. Remember when we started, I said liability can be based on fault, and there's liability without fault. We talked about intent, and then we talked about some intentional torts that helped us understand intent better. Now we've talked about negligence, which is another kind of fault, and now it's time for us to talk about a tort that's based on negligence. And here's where the thing gets a little bit confusing. Because